how can you convey a property subject to an agreement for sale or contract for deed? So you've entered into a real estate transaction and you've acquired an interest in the property by an agreement for sale and contract for deed. And as we discussed last week, that gives you basically all ownership rights to the property except for title. Title still remains in the seller. And so, well, now you want to convey that property. What do? Well, there's always the traditional method. You can find a buyer, and then the buyer's purchase price and either their financing or cash that they're going to bring to the table is more than enough to pay off the amounts owed under that agreement for sale. And then you, as the original purchaser, you're allowed to basically, or you're entitled to the difference between the payoff to the seller and the end buyer's purchase price, and just sell it traditionally. But what if you want to sell it on terms, right? You want to sell it so that end buyer is then responsible for paying or monthly. And so you're going to basically be the lender. Well, what do you do in that case? In that case, what you're going to do is you are going to, you have two options. One is if your agreement for sale originally had an assignment provision that allows you as the purchaser to assign the agreement for sale, you can then assign the agreement for sale. Or if the agreement for sale doesn't have the right to assign, but does not have a due on sale clause or due on transfer or due on alienation and doesn't prohibit subsequent agreements for sale, you could do a subsequent agreement for sale. So if you're going to assign it, what you would do is you would execute an assignment of the agreement for sale. It's like a one-page document, and you're going to assign it. And then from there, you will record a notice of assignment of agreement for sale. And then you will execute a warranty deed from you to the assignee. So to the end buyer, you'll execute a warranty deed, and hopefully you have a servicer in place, a loan servicer, or you will then deliver that original warranty deed to the loan servicer so that when that assignee performs under the agreement for sale by paying all amounts that are owed, by paying off the agreement, then the servicer will record the original warranty deed from the seller to you, the initial purchaser, and then the secondary warranty deed from you, the initial purchaser, to the end buyer, and then they're going to have title to the property. So that's the assignment method. The other method is an agreement for another agreement for sale. It's very similar, except you're going to actually have an agreement for sale document that then allows you certain rights to, forfeit the subsequent purchaser's interest in the property under that agreement for sale. And then you're going to record that secondary agreement for sale. And then you're going to execute a warranty deed from you as the original purchaser to the purchaser under the agreement, the new agreement for sale. And you're going to deliver that warranty deed to the loan servicer, so that when that secondary purchaser performs under your agreement for sale, which basically wraps the original agreement for sale, when they perform under that subsequent agreement for sale, then the first servicer records the warranty deed, and then from the seller to you as the original purchaser, and then from you as the seller to the end purchaser, so that once again, title's put in the name of the purchaser. So there's a process here for that. And, but you cannot, and this is important because I've had plenty of clients who have tried this, and some of them who have done it and created title issues and real messes. But you cannot convey the property. If you're a purchaser under an original agreement for sale, you cannot convey the property on terms via a warranty deed and a seller carryback promissory note and deed of trust, because you do not have title. So you do not have the ability to execute a warranty deed. You do not have the ability to deed the property to an end buyer. You do not have the ability to take a deed of trust back, because once again, there is no title transfer in an agreement for sale. So you don't technically have the right to title, and you don't have a right to convey title. And so if you do that, you're going to just create major title issues. You have to either assign the agreement for sale, or you have to do a subsequent agreement for sale. Next week, I'm going to follow up on this, and I'm actually going to talk about loans and financing by a purchaser under an agreement for sale, because you cannot do it just the traditional way. And we're going to talk about that. But as far as how to convey a property subject to an agreement for sale, you can do the traditional method so long as the buyer is going to bring cash to the table sufficient to pay off all of the other underlying obligations, including the amounts owed under the original agreement for sale. You can assign the agreement for sale if the agreement for sale allows for it, or you can do a subsequent agreement for sale as long as that's not restricted by the original